My lords will have observed that in relation to inventive step, the learned judge accepted the technical reasoning of my client's expert, Professor Westwell, which is recorded in the judgment. Three technical reasons were advanced by Professor Ward in support of a positive case that there's an inventive step on behalf of the patentee, and these were rejected by the judge. We say that in the light of that assessment of the technical evidence, the judge should have reached the conclusion that the claims were obvious. And we say at the heart of the judgment is an error of law, which was the judge wrongly looked for a particular context or a particular scenario for these technical findings to give rise to a finding of obviousness. We also say the judge was wrong to hold that applying the Pozzoli test introduced hindsight into the analysis. My lord, I was first going to spend a little bit of time examining the prior art. I'm then going to show my lords the rival positions assumed in the expert reports. That won't take long. Then I will turn to the law, and then I will go through the judgment. And my intention is to sit down before lunch to give my learning friend an opportunity. The relevant date for assessing obviousness is the 29th of March 2006. As the judge explains in the judgment, there were at this time known androgen receptor antagonists used to treat prostate cancer. But over time, prostate cancer typically becomes resistant to those therapies, and that's known as the hormone refractory state. There were various theories as to why this occurred, and which are extremely interesting, but unfortunately not relevant to my lord's decision today. The standard of care at the priority date was a drug called bicalutamide, which was an androgen receptor antagonist. The potential efficacy of these drugs could be measured in vitro using these LN-CAP cells. This is a line of cells derived from a metastatic lymph node of a patient with prostate cancer, and they can be cultured and perpetuate in culture. And they produce PSA. So PSA is associated with tumour growth or growth in these cells, and a reduction in PSA is a measure of prostate cancer cell inhibition. In addition, these cells, these LN-CAP cells, can be manipulated to overexpress the androgen receptors, and in this state, they're a model for this hormone refractory prostate cancer. So turning then to the posters at tab 1, and tab 1 is supplemental bundle, sorry, I beg your pardon. And my lords will see that there's, right in the centre, I expect my lords have had an opportunity to familiarise yourself with this at some level. In the middle there's enzalutamide, which was a known drug at the time, androgen receptor antagonist. And there was another drug there, which is RU59063. They're right in the middle of the poster, and that had been published in reference 3, which is noted on at the bottom of the poster. We needn't worry too much about the molecular modelling that's shown in the centre, but we then go sort of clockwise round, and my lords will see what happens is the methyl chain, or carbon chain with a hydroxy at the end, which you can see in RU59063, is replaced with a phenyl ring in RD6, RD7, RD37, RD54. So let's just take RD6 as an example. One has on the left-hand side this phenyl ring decorated with a cyano and a trifluorocarbon group, and that's consistent through the series and had been identified in this earlier publication, RU59063. So that's held steady. The central ring, obviously we're concerned with position X. That's right in the middle. We can see it's dimethyl in the case of RD6, and it's also dimethyl in the case of RU59063. And what the poster discloses is introducing this phenyl group on the right-hand side, top right-hand side, which introduces rigidity into the model, and this is important for the anti-androgen activity in the hormone-resistant prostate cancer cells, hormone refractory. My lord, that's the basic structure. Turning then to the histogram.
Sorry, can I just ask?
Yes, sorry.
You say we moved clockwise, and that's because presumably, according to this, it says rational drug design and synthetic chemistry, and it suggests you move in the direction of travel clockwise.
Yes, that's how it's presented.
Yes.
I think the evidence, no one was suggesting that this was a timeline of a research project.
Right.
That was necessary.
Okay,
but it's represented that way.
All right.
It's conception.
Right. Okay. So why do you move conceptually from RD7 to RD37?
Well, my law will obviously come on to that, but I mean, one moves from RD7 to RD37 and then from RD37 to RD54.
Well, I can see that, but I asked you the question about why you move from RD7 to RD37, which for obvious reasons.
Yes, well, my law will come back to that. There's no reason for moving from RD7 to RD37. Various compounds.
Well, there must be, because it's said to be the rational drug design of synthetic chemistry, so there must be some rational reason why you'd move from RD7 to RD37.
Well, my lord, obviously we have the information in the poster here, which there's no explanation beyond that. I think it's
is an indication provided by the in vivo assay that we see in the right-hand box. RD7 is in yellow and RD37 is in blue.
Yes.
And it's slightly. I'm assuming that this is one of these plots where a lower result is a better result. Is that right?
Yes, that's right.
So, but whether it's statistically significant, one can't tell.
One can't tell. And my lord will appreciate what this assay is, what they do. So the first assay, let's just go through perhaps one by one, which may assist my lord's answering my lord's question. The first one is hormone-sensitive prostate cancer cells, and one can see you're just measuring the PSA production, and if one looks at the DMSO, it sort of wanders around a little bit. That's just the control, the negative control. My lord will see that. You've then got bicalutamide.
Sorry, wait a minute. Sorry, you've lost me.
Yes, I'm on the top right, my lord. The histogram on the top right. And you've got, along the bottom, you've got 5 tests with different concentrations for each test.
Yep, got it.
So you've got DMSO is the first one, and that is that's a control, negative control. And then you've got bicalutamide, which is a comparator. We know bicalutamide has activity against hormone-sensitive prostate cancer cells, and indeed it reduces the PSA production, and going from left to right, it reduces it more depending on the concentration of the drug. Then look at the next one, RU59063, hasn't performed particularly well. RD2 and RD6 have, certainly RD6 has performed, or at least just eyeballing the figures, my lord's right to point out we don't have any statistics, appears to have performed better than bicalutamide, which was the standard of care. Now, if you go down to the next, so that's just having the cells in a metaphorical test tube, pouring the drugs on top and measuring the PSA production. So it's what we call an in vitro test. The next one is in vivo, in the sense of what happens, and although there's not a description on the poster, the experts agreed broadly what happened, and you have these LN-CAP hormone-resistant cells. They are then implanted into a mouse. We're not sure it's a mouse, but that was the assumption that was made, into the flank, and then the cells start growing. And then you administer to the mouse the either vehicle, which is negative control, bicalutamide, RD7 or RD37, and they're hormone refractory in this case. And then after a period, you measure the tumour with calipers, and you look at has it grown or has it not grown, and then you compare them. And we'll have a look at, briefly in a moment at the evidence on whether that was a material difference or not. So that's the in vivo assay, and then at the bottom we've got another in vitro assay, essentially the same as one at the top right, and you can see, my lords, that everything is so DMSO. Again, you see that the control wobbles around a bit, so it's not a very precise assay. Then you've got the bicalutamide, which is, as you would expect, disappointing because we know it's not effective against hormone refractory cells. And then you've got RD2, everything from RD6 is, it was agreed, materially better than bicalutamide. And again, just one could look at the...
and they're all giving a dose-dependent response.
They're all giving dose-dependent response, straightforward. Then if we... also we should note, looking at the structures, there is a comparison between RD37 and RD7. So the compounds, and to an extent RD54, so RD7 and RD37 are identical, save that one has the dimethyl at position X and the other has cyclobutyl at position X. RD54 is slightly different in that it has a cyano on the right-hand phenyl ring, but you've got a head-to-head comparison of the dimethyl and the cyclobutyl.
That's why I asked you why somebody would think it logical, rational to move from RD7 to RD37.
Well, we don't know what the inventors thought. We didn't give evidence, or it's not the inventor, the people who published the poster. But I think the relevant point is all these compounds are much better than the standard of care in the clinic, at least on their potency. They're all more potent than the best available in the clinic. So as we'll be going on, our case was that they're all suitable for use, subject to the PK issues, which we need to go on to next. So the problem with this series was not their activity. They all showed great activity. And the problem was their PK/DM optimization. So that's their, and that's dealt with on the left-hand side of the poster. And we can see, really we want to look at the table at the top left. The IC50s, that's a measure...
Sorry, before you go on, can you
yes,
just,
sorry.
Just remind me, I'm sure I've read it, what is the PK/DN optimization?
It's the pharmacokinetic drug metabolism.
Right.
So the problem is you can't get these drugs into the blood. Okay. And there are two potential reasons for that. One is that they're too lipophilic, so they like fatty places, so they don't go into the blood. And the other reason is they're getting metabolized in the liver. That's the DM. And it's just looking at the data in the table, one can see the log P's. So bicalutamide has a low number, which is good. Bicalutamide is sufficient. And RD162, a little bit more marginal, but that's satisfactory. And the important figure is actually how much gets into the blood, and that's the steady state in the right-hand column, the CSS. So a mouse is administered a certain amount of the drug, and that's how much you get in the blood. And with RD131, which doesn't have this motif, which I'm going to come back to, it doesn't, very little gets in. But RD162 is comparable to bicalutamide, and everyone was agreed that was acceptable. So they solve the problem of how to get it into the blood, and they do that using a fluorine atom on the right. So if you look at 162, on the right-hand side on the phenyl group, you've got a fluorine atom sticking up, and that's it impacts the metabolism. And then you've got this other group on the ring, which improves the solubility, and that's why this is better. The methylamide. So, my lords, I'm then going to go to the slides, and the slides are in many ways similar, but they are different. So it's obviously important, as the judge rightly does, to treat them separately. My lord, there are lots we don't need to go to, so I was just going to focus on the key slides. One is on, so it's a tab, it's the next tab, tab 2, and I was going to go to page 10. That's using the bundle numbers versus anything else. So. And this is, they've done structure-activity relationship studies, and here you have the description of where they've got to. So the right-hand ring is important for antagonist activity. Importantly, at position X, they say what happens there is you get hydrophobic interactions with the androgen receptor. And then talks about the other parts of the molecule which we're less concerned with at this stage. If we then look at 12, for example, there's very similar data, similar experiments. So if page 12, you've got not the same compounds included, but you've got you're looking at hormone refractory LN-cap cells. You've got these histograms. You're comparing bicalutamide to RD37. RD37 performs better. That's the in vitro stuff. And then if we go to, there's a lot more, all very similar in results. If we then look at page 16, again, my lords will see that's the same table, the same graph that you saw in relation to the poster. And then on page 18, my lords will see that this is the same data as we've looked at in the top left-hand corner of the poster. Importantly, my lord, because it is an important difference, there's no head-to-head comparison of the dimethyl with the cyclobutyl at position X or the cyclopentyl. So that's not disclosed in the slides. I beg your pardon. My lord, then turning to the evidence, and to be clear, we're focusing now back on, we just looked at the slides, we're going back to the poster. I wanted just to show briefly, it's important to understand what the battle lines were. So if we go to the supplemental at tab 3, and it's the evidence of Professor Westwell in chief. It's a lot of it set out fairly by the judge, but I just wanted to show my lords a couple of other short passages. So if one picks it up at 917, and that's on page 39 of the bundle. The witness has looked at he's looking at the three. My lords will see he's just been looking at those three compounds: the dimethyl, the cyclobutyl, and the cyclopentyl. And at 917, the witness says second sentence, skilled medicinal chemists will understand that the authors have made these modifications in 37 and 54 to investigate the impact of different size groups within the binding pocket. Here they have increased the size from a dimethyl group to a cyclobutyl group, and then to a cyclopentyl group. It's apparent that the dimethyl, cyclobutyl, and cyclopentyl groups at this position are all consistent with antagonist activity. My lord, we then can move on to 939, where he deals with.
So when he said, just to translate it, when he says it's apparent that dimethyl, cyclobutyl, and cyclopentyl groups are all consistent with antagonistic activity, I mean, what's he saying? There's no difference between them, or what?
He's not in that paragraph saying there's no difference between them. Just so my lord understands the target we're aiming at, it's not a requirement, we will be saying, to show that the dimethyl is better than cyclopentyl, or even as good as cyclopentyl. What it has to be is suitable, obvious that it's suitable, has a potency sufficient to take forward into clinical trials and so forth. So we're not in a competition to show that it's better than, or even the same as. We'll come to the. He comes back to this, so we'll come to this in a minute. My lord, if we then go to 939. again, this is Professor Westwell, taking the data together, he said the medicinal chemists would understand based on the IC50 values, this is the top left table, that all the RD compounds were more potent inhibitors than bicalutamide. Also, the skilled medicinal chemists would appreciate that RD160 had been shown to have better therapeutic potential based on its improved PKDM properties. He then moves to obviousness at 942. And he says he's been, at 942, he sets out the second sentence, I have in mind the importance of not contaminating my analysis with hindsight, and that for the purpose of this exercise I should put out of my mind knowledge I have from reading the patent as part of my involvement in this case, and the knowledge I've acquired after the filing date of my own research into enzalutamide. And then he's asked to adopt the following approach, and this is the structured Pozzoli approach, which is in the authorities. And it does require, it does require to identify the differences that exist between the matter cited forming part of the state of the art and the inventive concept of the claim, or the claim is construed. And but then you have to put that out of your mind, the invention viewed without any knowledge of the alleged invention. This is the last step. This claim, do those differences constitute steps which have been obvious? And then 944, I've identified the notional person's skill in the art. He then deals with the claim, 946. I was going to pick it up at 949. From the disclosure in OOC, the skilled medicinal chemist would expect certain variants of 162 to have the same or similar activity, and therefore also have therapeutic potential. In particular, the skilled medicinal chemist knows from the teaching in OOC, cyclobutyl at bottom right can be substituted with dimethyl or cyclopentyl, as shown in RD7 and RD54, without having a significant impact on in vitro activity. And of course, we'll come on to that. And then, if I could just invite my lords to read 950 rather than my reading it out. He's explaining the importance of the changes on the left-hand side. Then at 951, it says it would therefore be immediately obvious to the skilled team that following the two compounds would be likely to have the therapeutic potential that was similar to that of RD162. And so his reasoning has been that any of these substitutions as X would work, and once you sorted out the bioavailability with the fluorine and the methylamide, it's immediately obvious. His evidence is that these three would have a therapeutic potential similar to that of RD162. Not saying identical, similar. And then although the judge was critical of this, we say this was wholly appropriate. That's at 953. I've been asked to consider whether changes to other parts of RD162 would also result in molecules which would be expected to have similar therapeutic potential. So that was appropriate. This was appropriate due diligence to do with the expert. Say, look, are you not just steamrolling to position X and forgetting everything else? And asking the witness just what his position on other parts of the molecule are. So that was wholly appropriate. And he says other changes could be investigated, but the activity of such molecules prior to testing would be more uncertain. And therefore, their therapeutic potential as compared to RD62 would not be immediately obvious, in particular because of the potential for disadvantages, PKDM properties. And then he goes on to explain why that is, why one would retain the left-hand side, why one would retain the methylamide, and why one would retain the fluorine. So the answer comes back it wasn't obvious to make other changes. So the answer comes back no, having done that due diligence. That's all I needed to show you in that report. I was then going to go to Professor Ward. Again, it's really just seeing where the battle lines are drawn. And you can pick it up at 52. So this is tab 8, my lords. Pick it up at paragraph 52, which is page 163. Just where the poster is being introduced, just to orientate the court. Then we can move on to paragraphs. Sorry, I think that's bad. Sorry, page number. Give me a second. Sorry, apologies. Yes, we can pick it up at 64, paragraph 64. And this was his evidence in answer to my Lord's question about the graph in the middle. Is that a material difference? He deals with that at 64. The skilled chemist would observe that over time, this is sort of 5 lines down, skilled chemist would observe that over time it does appear that RD37 resulted in a marginally smaller fold increase of tumour volume compared to the RD7 line, albeit the skilled chemist would note that the lack of error bars and or statistical confidence in the graph and lack of information on the testing regime and assay conditions. And my Lord, remember this is just a relatively crude measure of tumour size, which is necessarily impacted by the shape of the tumour and so forth. It's not measuring the level of a chemical in the substrate. Then if we go to pick it up at 66, second sentence, whereas bicalutamide does not appear to show any significant activity in reducing PSA levels in the HRPC setting, all RD structures show much improved antagonist profiles and more significant reduction of PSA, particularly from RD6 onwards. So all better than the standard of care, at least in the assays. Then, my Lord, we can then pick it up at 72. In the middle of that paragraph, there's a sentence that starts additionally with RD162. My Lord's had that. A fluorine is attached at the position of the right-hand side phenol ring. The skilled chemist would find it remarkable that it's possible to preserve the biological activity against the target.
Sorry, I've missed the paragraph.
I do apologise, my Lord. So paragraph 72, it's in the middle, dead in the middle of that paragraph, 3 words in, additionally.
Yep, sorry, got it.
Yeah. Additionally, with RD162, a fluorine is attached at these, so he's explaining where the fluorine is attached. Skilled chemists would find it remarkable that it is possible to preserve the desired biological activity of the target whilst modulating the PK and other properties. So it didn't impact the IC50, particularly by adding this fluorine and the methylamide on. And then he goes on to say, that gives the skilled chemist a portion of the compound, the right-hand side substitutions, that they can vary and seek to modify while retaining a degree of confidence that the desired biological activity would be preserved. So these modifications can be put in and there's an expectation you'll preserve the biological activity. That's what the witness is saying there. And then the approach to the poster starts at 73. I just wanted to look at the second half of this paragraph, which is over the page. Though it's not disclosed in the poster, the skilled chemist would understand that the authors likely had in mind a target product profile underpinning their work, having determined their intended biological target and mechanism of action. So the target product profile is what type of compound are you after, and what it is in this case is an AR antagonist, androgen receptor antagonist, and that's apparent from the poster. And then at 75, he picks this up later on. He says, based on the limited data in the poster, it would appear to the skilled chemist that the author of the poster have, with RD162, reached their goal of developing an AR inhibitor for prostate cancer. And then a couple of sentences down, 4 lines, 5 lines, he says, as such, from the skilled chemist's perspective, based on what is in the poster, they would not presume that there is much more, if any, medicinal chemistry to be undertaken. So he comes back to that. So we can now jump to 133 on page 192. And this is where he deals with obviousness. I can take this relatively quickly. And although criticism is made of the witness, well, it may be being made, the criticism that the witness used the Pozzoli approach. Nevertheless, Professor Ward did the same. So in 133, he's setting out the Pozzoli test, albeit without the numbered subparagraphs. And this is completely conventional. He then deals with the poster heading, and then at 136, he deals with his 3 technical points. The second sentence of 136, the third sentence, is I have explained at paragraph 74 and 75 above, you've just seen that, why having the poster, which has no conclusions or suggested next steps, there is no motivation for the skilled chemist to take up or continue with any medicinal chemistry work. Then at 138, he raises his next point. Further, the preference for a cyclobutyl substituent in the later RD series compounds would tend to suggest to the skilled chemist that some additional bulk is favoured. The poster does not explain the thinking behind the expansion from gem-dimethyl to cyclobutyl, but the skilled chemist's best inference would be that it is consistent with there being a hydrophobic pocket into which the substituent can fit, with the bulkier cyclobutyl substantially potentially filling the better in such a pocket, at least relative to the gem-dimethyl. So it's a snug fit.
Pocket in what?
In the androgen receptor. So the androgen receptor, these molecular receptors have little sort of dents and so forth. And
but if it's more bulky, is it fits and stays if it's more bulky? Is that
yeah, a snugger fit will mean it comes off less often. That's the sort of underlying. But the judge rejects this. We'll come on to it. But just so that my lord,
is that why they would, for example, try to move from RD37 to RD54 in your logical? Was that one aspect of it?
Yes, as I say, all this gets rejected by the judge. But there's been suggested that it's the best, the snug fit, the Goldilocks fit is the cyclobutyl, and will be a slightly better than the gem-dimethyl because it's a slightly snugger fit. That's what the witness is suggesting. There was a great deal of cross-examination on this, but it eventually gets rejected. And then at 139, the third point is raised, and that is that there are known metabolic liabilities, and that was no one would like a dimethyl because they tend to get metabolized. And so that was the witness's case. There's 3 reasons as to why it wasn't inventive. Importantly, Professor Ward, this is an answer to my Lord's question, subject to the snug fit point, Professor Ward does not contend that the dimethyl would not be pursued because it was thought to be less active than cyclopentyl. In the light of the data in the poster, does not make that point. And the judge doesn't place reliance upon this either, as we shall see. Although my learned friend does like to flirt with this in his skeleton. And finally, this is the last bit of the evidence. I just want to go to Ward 2, just so that I've not been incomplete. That's at tab 9. And go to paragraph 31. This is again on the point my Lord put to me, page 206. The activity of paragraph 91 of Westwell states the activity, he's quoting from it, activity of RD7 and RD37 in the HR antagonist assays was similar. I broadly agree, but repeat my more detailed comments at 64.1. As between RD, and he requotes them, RD7 and RD37, this level of very detailed analysis is challenging to do graphically. The skilled person would observe that over time it does appear that RD7 resulted in a marginally, he does use the word marginally, smaller fold increase of the tumour volume compared to RD7, albeit the skilled chemist would note the lack of error bars and or statistical confidence in the graph. So that was that was his evidence, Professor Ward. My Lord, with that I was going to go to the law. That introduction, and then before going to the judgment, be careful. The Pozzoli-Windsurford structured approach to inventive step is well established in the authorities. We put Pozzoli in the bundles just in case the court wants to look at it, but I was just going to take it actually from the Supreme Court in Actis and Lilly, which is at tab 4. Page 158 says that. So it's necessary for the court and indeed experts to identify this.
Sorry, I'm struggling to get. I'm sorry, I was struggling to get you electronically. Give me the electronic bundle number again, please.
It's the page is 158. It's JA tab 4.
Sorry, I should have looked at my screen here. Sorry. Yep, got it.
Yeah.
Yep.
And so JA158. You should see it, paragraph 60 in the middle, my Lord. Just the Pozzoli test, which we had a look at earlier, being approved by the Supreme Court or referred to by the Supreme Court, and just spending a little bit more time on it. So the third question, identify what, if any, differences exist between the matter cited as forming part of the state of the art and the inventive concept of the claim or the claim as construed. So you do have to focus in on the difference between the prior art and the invention. Now, it's absolutely necessary to do that. If courts did not have that difference in mind, they would be, and experts as well, they would be tasked with listing everything that is obvious in the light of a disclosure, a piece of prior art, which would be too loose an analysis. This would lead to expert reports of extraordinary length and complexity, probably of infinite length and complexity, if one really thinks about it. So it is necessary for people to have in mind what it is we're talking about, for the experts to have in mind what is the difference they need to focus on. But at the same time, they have to be vigilant with regards to, when it gets to question 4, to consider the hindsight. So without, you then have to, having identified that difference, you now have to put the alleged invention out of your mind without knowledge of the alleged invention. And this is, of course, what, at least as set out in his expert report, what Professor Westwell did, he said he was doing. Then if we just pick it up at 159, there's a reference to Connor and Angiotech. Says the question of obviousness must be considered on the facts of each case. The court must consider the weight to attach to any particular factor in the light of all the relevant circumstances. These may include such matters as the motive to find a solution to the problem, the number and extent of possible avenues of research, the effort involved in pursuing them, and the expectation of success. Mr Justice Kitchens, he then was, lists factors as illustrative, not exhaustive. And that's all well established. And then finally, I just wanted to pick up 161. There's a reference just before C in the right-hand margin. In Brugger and Medicaid, Mr Justice Laddie, that if a particular route is an obvious one to take or to try, it is not rendered any less obvious from a technical point of view, merely because there are a number, and perhaps a large number, of other obvious routes as well. So the fact that there may be other, may want to go off and do structure-activity relationship studies or take forward other molecules, doesn't make the obviousness of this molecule doesn't detract from that. Says, I agree, as a result, the need to make value judgments on how to proceed in the course of research is not necessarily a pointer against obviousness. And then...
but it might.
Another point.
But it might. But it might be.
In some cases, it might be, of course, yes. but not necessarily so. Another important matter to keep in mind, this is that we're concerned with technical obviousness, not commercial obviousness. Things can be obvious which you would not necessarily want to do for commercial or even practical reasons. I was going to look at pharmacia in this regard. This is at tab 2. Pharmacia was a similar case in the sense it concerned these chemical compounds or anti-inflammatories in this case, and they had lots of structures and so forth. The patent was held invalid for insufficiency and obviousness. They cite, I'm just trying to work out which judge it is, I've momentarily forgotten, but there's at 122, so it's page 78, so the judge held the patent, so it was Mr Justice Mellor, he then was. The judge held the patent both as amended and unamended invalid as being obvious. He rightly set out the law in this way. And then I was going to pick it up just after the citation near the second hole punch, if that probably doesn't help if you're electronic. It says there are a number of arguments, my lords and management.
So which page are you on, I think?
Sorry, page 78, my lord, of the bundle, I do apologise. 122 of the, paragraph 122, page 78 of the bundle. And this is the Court of Appeal, and they're approving what Mr Justice Pumphrey had said about the law, and they state just after the second indentation, it said there are a number of arguments which are frequently advanced to fend off an attack of obviousness which need to be considered with care. The first, and perhaps the most commonest, is that there is a number of possible courses of action for the skilled man to pursue in the light of particular disclosure. No particular course is obvious. This is wrong. All courses of action which present themselves without the exercise of invention are obvious. That's a citation of the program. The second is that the test in such a case is whether the skilled man could rather than would adopt a course of action which would bring him within the claim. The test formulated in this way almost invites the tribunal to consider irrelevant considerations such as commercial attractiveness. In each case, the only question is whether something within the claim was technically obvious to the skilled man in the light of the disclosure relied upon. Then over the page at paragraph 123, there's a citation which is then qualified, a citation from Mr Justice Laddie in Herxt and BP. I just wanted to look at that and then look at the qualification. So if we look at the citations, before a step from the prior art can be held to be obvious, there must be some reason why the skilled man in the art would wish to take it. If he has a problem and the step would occur to him as a solution to it, then he has a reason. But there is no requirement that it be demonstrated that the step would have been expected to produce significant commercial advantage. The problem might be very small. The courts will assume that he may just want an alternative way of achieving essentially the same result as in the prior art. Thus, mere workshop modifications, and it's this point that the Court of Appeal don't like, none of which could be expected to produce significant technical and commercial benefits, are still obvious. To adopt an example sometimes given by Mr Justice Jacob, as he then was, if it is known to make a 5-inch plate, it is obvious to make a 5 1/4-inch plate. Technicians and businessmen frequently want to make trivial variations in established or known products. Similarly, if the prior art disclosed 2 wooden parts held together by screws, it would be obvious to glue them, even if doing so would not be expected to advance the industry. And then, dropping down to 124, the statement of law was, I expect, apt on the facts of that case, but should not be followed generally. A step from the prior art, albeit made without reason, can still be obvious. The judge categorises such a step as workshop modifications, and in so doing introduces a test not in the statute, namely whether the step from the prior art was a workshop modification. The statutory test is obviousness, and any modification which is obvious will not be patentable, whereas one is not obvious will not be, which is not obvious will be, sorry. The true test is made clear in windsurfing is to ask whether the invention was obvious. Whether or not there is a reason for taking the step from the prior art may well be an important consideration. That does not mean that it is an essential requirement of the conclusion of obviousness. Then, my lord, I'll just show this because my learned friend says that well, sorry, just while we're on that, I mean, I think that the point is, Teva technically obvious alternatives are obvious, even if they would not bring an advantage. And in practice, no one may want to make a dinner plate of a different size that's not been made before, 5.5 inches in this example. And in practice, nobody may want to replace the nails holding the wood together in a shed with screws or glue. But these are all obvious alternatives. One does not need a special context or a special scenario to conclude that screws are an alternative to nails, or vice versa. Now, I just wanted also to go to 141. My learned friend says you can't make predictions in medicinal chemistry. And every case turns on its facts. But I just want to just remind the court, seeing as we're here, that in this case, that's precisely what was held. So 141 says, for my part, I would have preferred the evidence of the medicinal chemist, Professor Baker, as to whether it was routine to investigate close compounds to that of Professor Baldwin. Certainly the judge was entitled to do so and to come to the conclusion he did in paragraph 171. It was that structurally there are clear similarities between dupe 697, that's the prior art, and its close dye-substituted analogues, which is patented. It's a matter of reasonable prediction that they will have similar activity. I think that a medicinal chemist wishing to investigate the structure-activity relationship with DuPont 697 would think of making its 3,4 diaryl adducts with a view to seeing whether they're active. So just there's no general rule that matters can't be predicted in medicinal chemistry. My lord, I was then going to go to RIM, which is at remind me where it is, sorry. Tab 3. Yes, research in motion, tab 3. And go to 112, paragraph 112, so I think the page number, that's page JA124. This concerned, I think, handheld devices like BlackBerries and phones and so forth, and how information got across a firewall, and there was an alternative which was HTTP, and that's what the background to what the court is considering. So at 1112, you just pick it up. RIM accepts that there was no positive motive in this scenario to make the change, but it submits that that does not matter for Pharmacia Herc's reasons. The modified system is nevertheless obvious technically. It does essentially the same thing in a different way. The technique of passing data through a firewall using HTTP was a well-known tool. Why should anyone not be free to use it if the need ever arose? And just picking it up at 114, second sentence. If one had already decided to do something in a particular way, it will seldom be logical to retrace one's steps and do it in another way, particularly if that alternative way provides no advantage, as it would not in the case of a licensed Lotus Notes user. To say Lotus Notes users who has already configured the firewall that a different port is available will not solve any technical problem with which he is faced, provide him with any technical benefit. To use the familiar example, if a piece of wood is satisfactorily screwed together, there is no other reason to take it apart and glue it instead. It's certainly not invented to do so. It does not make it invented if you say that doing so avoids the technical problem of how to fix together two pieces of wood without using screws. And my lord, this is well established in the authorities. Just briefly, two other authorities. I was going to go to tab 7, to a decision of Mr Justice Jacob, as he was back then, and that's JA274 of the bundle. And this is the role of expert evidence, well familiar to my Lord Justice Arnold, and just at the bottom of the page at H, he says what really matters in most cases is the reasons given for the opinion. As a practical matter, a well-constructed expert report containing opinion set out the opinion and the reasons for it. If the reasons stand up, the opinion does. If not, not. So one doesn't just look at conclusions, look at the reason behind those conclusions. And we remind the court that the reasoning of Astellis's expert evidence, Mr Ward, was rejected, entirely rejected, and the technical reasoning of Professor Westwell was not challenged. We'll see that. And then if we go to Metatech, that's the last one, tab 10. Tab 11, I beg your pardon. So it starts at 416. I was going to pick it up at 485 of the bundle. That's paragraph 324. And again, it's the same point. There's a decision of my Lord Justice Arnold in the High Court, 324 in Glenmark, Welcome. What matters is whether or not the invention is technically obvious, not whether it's commercially obvious. Does not necessarily mean that commercial considerations are relevant. The mindset of a skilled person may be conditioned by commercial consideration only to consider certain types of technical solution, as in Dyson and Uber. We absolutely accept that. And then in the next paragraph, there's a reference to Herx and Celanese, and then halfway down, this is Mr. Alexander. However, again here, it is dangerous to make too much of it as an isolated factor, because a product can be obvious even if there's no reason actually to make it at the priority date, and a skilled person will believe it to be unusable. A 100-centimetre dinner plate, to adapt a familiar example. Modern thinking judgment was moving to the embracing a metric system after all the 5-inch dinner plates. It's also important to bear in mind that the motivation can lie in the wish to make a different product which operates in a similar way, not necessarily a better one. My lords, then I was going to turn to the judgment. Before turning to the judgment, sorry, there are just a couple of points I should pick up. First of all, how we closed our case. That's in the supplemental bundle. Go back to the supplemental bundle. Tab 16. And if we pick it up at page 398, so the bundle page number, we can see we're just kicking off with obviousness over ook. And then I was going to go to 77 on the next page. The claimant's primary case, as it is obvious for the skill team who read ook to make the modification to RD116 so as to make a compound where the cyclobutyl substituent was replaced with the dimethyl, and that such a compound would be expected to be better than enzalutamide in an in vitro assay and therefore have potential for use in therapy. And then we cite the paragraph of Professor Westwell. That case was always our primary case. We never wavered from that case. And we then deal with 85, get at 85. The claimants also advanced a secondary case based on the evidence of Professor Ward that it would have been obvious to the skilled team to adopt RD162 as their hit compound and to make and test close analogues of RD162 prime. We deal with that in 3 paragraphs that follow. In oral submissions, I should just well, actually, we then go on and deal with the 3 reasons advanced by Professor Ward in the rest of this section. And we describe them as the misguided, the misleading, and the abandoned in that order. In oral submissions, we should just look at that, which is at tab, same bundle, tab 15. I'll give you the page number in a moment. Transcript 662, page 382 of the bundle. And then this is 662 line 3. Anyway, we then go to our secondary case. My lord, can I just take a moment to build this up? Whether it's a distinct case or a rejoinder to what my learned friend says, in primary is a moot point. However, it arises if you are against us on the facts that the skilled person would think that it's likely that these variants of cyclobutyl and the cyclopentyl will be active. So that was the primary case, and was that those will be active, and this only arose if we lost on that. Does not look like that's going to happen on the evidence, but it's possible my lord will say, well, I'm not persuaded Professor Westwell may have been a little too optimistic. That is the sort of hypothesis that engages this second case, if you like. Absolutely not our primary case. And my lord, we're not pursuing that case, the secondary case, before you today. My Lords, we found Professor Ward challenging to cross-examine, and we were highly critical of him and the way he delivered his evidence. The judge was receptive to some of those criticisms, as we'll see, not all of them, but the important ones. In an attempt to make common ground with the witness, we had to put various hypotheses to him. That is not an unusual approach. Otherwise, it's like wading through treacle. But a theme in this case has been for my learned friend to say, well, you put this hypothesis to the witness, that is your case, and then seek to knock down that hypothesis and knock down that case. And we refer to these as the Aunt Sallies, which we'll see as we go through the judgment. But we just make that as a general point. It'll make more sense as we turn up the judgment. Finally, before turning to the judgment, we should just have a look at the patent. I'm not sure the claims are actually set out in the judgment. I'm not sure that they are, so let me just show them to my Lords. They're at tab 2 is the patent. That starts at page 94 of the bundle. And perhaps we'll just have a look at, it was a patent of materially more breadth. The application was a materially more breadth than RD162 prime. So one RD162 prime gets a little attention. There's no added matter or any complaint about that. But it's disclosed on paragraph 11, which is on page 97. That's a sort of consistory clause. Then there's a reference to a method of synthesis, 17. And indeed, there's another reference in example 56, how you make it. No complaint about that. At 43, it says figure 21 is a graph representing PSA absorbance associated with LNAR cells treated with various concentrations. And there's another reference to figure 21 at 245, that's page 157, I beg your pardon, the bundle. Essentially saying that...
Sorry, I mean, you're not asking us to go to the graph or anything like that.
I'm going to go to the graph just to show there's another reference at 245 to figure 21, and then we're going to go to figure 21. So, but the reference to figure 21 is just at 157, just so that my Lords have it in mind. Two short references. And then if we go to figure 21, which is... Right, that's my note.
197.
197, thank you. Yes, 197, I'm very grateful, my Lord, thank you. There's not a great deal of information about it apart from what one has already seen, and just we've got to be a little bit care. So the first one, nobody knows the difference between 21A and 21B. The assumption is that they're just a repetition. Again, similar, you've got 1, 2, 3, 4 compounds in the first one, PSA absorbance. And RD162, you can compare. The things, they're not confidence limits. These will be standard error of the mean. And they, anyway, 162 and 162 prime, one can look at the relative heights of those.
So what's the point you're trying to get across?
Just showing my...
I'm not sure what point you're making.
No, so my learned friend flirts with, if I can put it that way, the fact that 162 prime is better than... 162 prime is better than 162. And he, as a matter of fact, as disclosed in the patent. And I'm just showing what the data in the patent is. It's a very short point, my Lord. If you then go to 21B, 162 is the second lot after vehicle, the second block, and 162 prime is the third. The next one is 162 double prime. So take your choice. But importantly, the patentee, the authors of the patent, do not contend anywhere that 162 prime is better than 162. And then finally, if I can go to the claims, just so that my lords have them in mind, and if anything turns on them, they're on page 173. I think the claims that were focused on were claim 1, which is a claim, product per se claim, and there are EPC 2000 claims in 9 and 10, so you've got the structure of the compound, and then at 9 you have pharma receptors salt or constituted wherein the hyperproliferative order is for manufacturing prostate data, and 10 you've got another one. And then there are some some Swiss form claims at 15 through to 18, my lord, just so my lord is aware. But, nothing turned on claim construction or any we were treating all the claims the same for the purposes of the inventive step. So turning to the judgment. If you look at 136, this is in the common general knowledge section. If you want to compare potency of two compounds, this is how you do it. You use an IC50. So half maximal inhibitory concentration is a measure of potency. The quantitative measure that
Sorry, do you have a page number?
I'm sorry, it's on the judgment. I haven't got the bundle numbers. 31.
31.
So I need to add one. You should see 136 at the top of the top of the page. And this is common general knowledge, accepted to be common general knowledge. IC50 is a measure of potency. It's a quantitative measure that indicates how much of a particular inhibitory substance is needed to inhibit the activity of a given target by 50%. IC50 values are typically expressed as molar concentrations. The IC50 of a drug can be determined by constructing a dose-response curve, examining the effect of different concentrations. IC50 values are used to compare the potency of two or more antagonist drugs in development or against an approved drug. Numerically lower IC50 value indicates the higher potency. It was IC50 as you saw in the top left. It wasn't common general knowledge that you use any other approach to measure relative potency. It wasn't established or even said to be common general knowledge that you use any other method to compare relative potency. If we can go to 144 on the same, that indicates there's one issue at the end of statement of agreed CGK. The parties identified one point in dispute, common general knowledge regarding the metabolic stability of terminal dimethyl groups, and the judge comes on to that. My lords will appreciate that the common general knowledge is an agreed document that is produced during the course of the trial. And then if there are issues the judge needs to decide on common general knowledge, they're set out as disputed issues. And this was the only disputed issue. The law starts from 177. And also I've addressed you on the law. We have no criticism of the passages the judge sets out. Of course, our criticism didn't apply them appropriately. Then I was going to pick it up at 195. This goes to my learned friends flirting, as I put it, with the fact that perhaps the patent has disclosed a more active compound, 162 prime over 162. And if I could just invite my lords just to read that paragraph. So the judge rejects that as a relevant legal consideration. That's an established legal principle, which is familiar to my lords. Then I was going to pick it up at 197. In both their opening and closing submissions, Astellas addressed a number of submissions, please take this a little carefully, addressed a number of submissions directed to their perception that the claimant's case was that the change from RD162 to RD162 prime was trivial and obviously so. These comprised a series of reminders from the relevant case law, which I summarise as follows. Now, my lord, I can't make submissions on Astellas' perception or the court's interpretation of Astellas' perception, but we've diligently checked the transcripts and our written submissions, and it was never the case that we submitted that a change of position X was trivial. We never described it as such. Our case was that the change was obviously consistent with similar activity. And my learned friend, in his skeleton on this appeal, says this is our case. It's one of the, he introduces the concept of triviality again. Triviality came from my learned friend, this suggestion of triviality. He advances it and then knocks it, says it's our case and then knocks it down. This is one of his Aunt Sally's we submit, and I'll leave that to him to deal with further. My lord, I'm then going to jump to 233. And I don't know if my lords were, I'm now sort of getting in the meat of the judgment. I don't know if my lords wanted to rise for 5 minutes for a shorthand break, or whether you'd like me just to press on.
We don't generally do so.
Oh, you don't. Fine. Let me keep going.
But if we feel the need, we'll let you know.
Yes, okay, thank you. So the judge starts off by setting out the, we can consider, we can see, so this is page, I think, 51 of the bundle. And he sets out 233, the evidence that we've looked at from Professor Westwell. And then at 237, the judge then deals with Astellas' positive case of inventiveness. And he sets, you've seen, 1, 2, 3, so this is no motivation, snug fit for the, the less metabolically stable, and the size of the hydrophobic pocket. And the court will dismiss of each of these 3 reasons, characterising them respectively. These reasons were also the focus of the defendant's criticism of Professor Ward. Accordingly, it's necessary to analyse the evidence and arguments. I'll first consider the criticism of Professor Ward. We can then jump to 247, where he deals with the no motivation. This was the end of the journey position that Professor Ward was adopting, and that's at 247, which I think is 56 of the, probably of your bundle. It says, as the claim, this is 248, as the claimant submitted, the basis for this opinion was unclear. In the cross-examination, Professor Ward accepted there was no statement in the post to that effect. And then and then 259, having been through the evidence, the judge says, in the whole passage of cross-examination, Professor Ward seemed to me to be bending over backwards to avoid accepting some fairly straightforward propositions, including some of which he'd previously written about in textbooks. And then 261, overall, in my view, there's no support for the no motivation contention. I do not consider Professor's point represented the position of the views of the skilled team. Furthermore, there was a degree of exaggeration in Professor Ward's suggestion that there had been active selection of cyclobutyl at position X. It is clear that the authors of the poster have made the change from dimethyl to cyclobutyl and retained cyclobutyl. You fair to conclude that there does appear to be a preference for cyclobutyl, but there was no pairwise comparison or any other data directed to this. On this point, Professor Ward was reading too much into the poster, in my judgment. He then goes on to dimethyl less stable, and sets out at 262 what that was. Then at 267 we see his conclusion. Little or no substance, raised in a misleading way. And then he deals with the hydrophobic pocket, which my lords asked me about earlier. The further point in Professor Ward's report was that the skilled medicine would consider the bulkier cyclobutyl substituent potentially feel better in such a pocket. And then he deals with this at 274, his conclusion, page 61. Overall, the position was that there was no information upon which to reason that the cyclobutyl was a better fit, other than the fact that cyclobutyl had been adopted in RD37 and retained. Having considered all of these 3 points made by Professor Ward in the cross-examination on them, I found it difficult to avoid the conclusion that Professor Ward was at times engaged in the process of trying to find or generate arguments against obviousness. Then he moves on to Astellas' attacks on the primary evidence on the poster, and importantly at 278 records, as far as I could detect, no challenge was made to the technical reasoning which Professor Westwell put forward in support of obviousness over the poster. Instead, Astellas accused Professor Wall of approaching the Pozzoli analysis incorrectly. So, the judge then has a title obvious to do an SAR. The judge rightly recognised that this is our secondary case at 280. It was not part of Professor Westwell's case as to why the invention was immediately obvious. It arose from evidence of Professor Ward, and as we say, it only arose in the event that we failed on the primary case. And Professor Westwell's case was immediately obvious without having to engage in a further obvious SAR study or non-obvious SAR study, either way. Now we need to go to 285, which is the cross-examination. We need to approach this section of the judgment with care, and it's just necessary to go back in the transcript a tiny bit just to see how it starts. So if we go to tab 11 of the supplemental bundle, and I'll give you the page number in a minute. So it's of the bundle number, it's page 254. I just wanted to pick it up at 157 on the transcript, just at the top. You need to look at this with a little bit of care. Well, we discussed SARs in the common general knowledge, so it is part of the medicinal chemist's toolkit, if you like. Mr. Liquidopoulos says, I'm not suggesting otherwise, we did not do so on obviousness steps. Just on the pharmacokinetic issue and the switch between the cyclobutyl and the dimethyl. This is the answer, sorry. I said that was a minor change, and that relates to this property of log P. Log P is a measure of lipophilicity. It's an important parameter in drug design, and medicinal chemists would know that a switch from cyclobutyl to dimethyl in that position would have a very minor, a very insignificant change on log P. Those things can be done very easily when you can predict log P values, readily available software. So the reason that is important is that it is a measure of lipophilicity that helps you to understand biodistribution and membrane permeation. So in terms of PK properties, it would be a fair assumption to say that a switch back, if you put it, to the dimethyl would have almost insignificant effect on values like log P and also on biodistribution stability. So those are reasonable things to assume you know, with the obvious caveat. I keep saying you do not explore. And then importantly, so this is about we know this is about the posters, perfectly clear from context. And the witness says that is your evidence you've given about whether it's not obvious. The change is immediately obvious, to use your phrase, in relation to the poster. I was putting to you that both in your first report and your reply report, when you come to look at what is obvious to do in the light of the slides, and then he says obvious steps, and then we can go back to the judgment. So importantly, the witness is that the cross-examiner is saying, I don't want to talk about the poster, I want to talk about the slides. And this is very important, and it's important because there are these big differences between the slides and the poster. There's no head-to-head comparison, so we need to bear that in mind when we get to this passage of cross-examination. So I'm now going back to where we are in the judgment. It just may be more convenient to pick it up in the judgment, so you can stay in the transcript if you prefer. So we just need to look at this a little carefully as the judge places reliance on it. obvious steps to take in light of the slides. You did say this is near the beginning. You did not talk about doing SAR. Okay, so we're on the slides and the failure to talk about an SAR in the context of the slides. You did not set out what the goal might be.
Sorry, where are you in the judgment?
I beg your pardon, my lord. I'm on page 63, so 285, where we
285.
left off. I'm sorry, my lord, I'm jumping around. So I just picking up from line 7 at the beginning, obvious steps to take in the light of the slides. You did not talk about doing a SAR. That's correct. You did not set out what the goal might be. You did not set out what might be tested, the order of testing, why one might change just the dimethyl and cyclobutyl at position X. You did not discuss what else might be done. You did nothing. What you said was, well, it's an obvious change. I'm putting to you, it's quite a long question, I'm putting to you, that is all you thought about at the time. You did not think of doing any SAR, large, small, medium, or otherwise. So we're in the context of the slides, saying you didn't think of doing any SAR. And the witness says, yes, but a medicinal chemist would do an SAR, and we accept doing SARs is obvious. Whether it is large, small, or what it is that they would do, they would be interested in further exploration around the substitution groups, which would include the hydrophobic region, and again, that's a reference to the slides, as well as the aryl. That is the nature of medicinal chemistry. So as we discussed, one way that they would do that is either because they're taking forward RD162 and they hit problems, or they may have a target given to them by the biologist, or they may have another set of targets wish to do, a bit like you did in their research. Of course, you have not discussed any of those in your evidence, have you? No, because I was asked to assess obvious in terms of, and then the witness stops at that point, changes tack. You could do an exploratory SAR and make more wholesale changes, but in terms of this hydrophobic region, is reasonable on PK grounds. Any premises like log P that these changes in the hydrophobic region taken away, single carbon atom would not materially affect those properties. So yes, I did not discuss SAR building on 162 in the expert reports. That could be done, but that might involve more substantial changes to the substituents. And then he picks him up on that answer that gets terminated. I think you said you did not, because you were asked to assess obvious in terms of, I'm assuming what you were asked to say in terms of the difference and assessing the differences between gem-dimethyl and a cyclobutyl. Well, that is absolutely the Bozzoli test. And we go over, and with that changed in mind, you were then saying, well, is that going to have an effect or not, or make any obvious changes? That is what you were really doing, is it not? Yes, assessing obviousness of that change in the light of the material presented in the public conference. Yes, so again, in light of the slides. That is right. So when you say the obviousness of that change, what you were thinking was, if I'm asked about the change between cyclobutyl and gem-dimethyl, do I think the change is an obvious one to make in the light of what I have here? Yes. So, my lord, that's an absolutely appropriate description of the Bozzoli test. And then if we go to 287, this is the judge, trial judge, 3 important points emerge from that passage. First, that when challenged, Professor Westwell did not say that his reasoning was part of an SAR. Correct. It's not. Second, that Professor Westwell regarded the obvious steps he talked about in his reports as distinct from an SAR. Yes, that is correct. We've also seen that. Third, that he was asked to assess obviousness in terms of the difference between gem-dimethyl and cyclobutyl. However, I keep in mind that when Professor Westwell said this, he might have well have been referring to Bozzoli step 3. Identify the differences. I've already mentioned he set out the Bozzoli approach, and there are clear signs of written evidence that he was endeavouring to follow that approach. So yes, absolutely, we agree. This was just describing the Bozzoli approach in his expert report. 288, Stella submitted a fourth important point, was also emerged from the final question and answer, that in that answer Professor Westwell effectively admitted that he had the target in mind when concluding the step from ID 162 was obvious. However, I do not consider that was clearly established. And then dropping down to 289, Stellas nonetheless submitted that it was clear from his written reports that Professor Westwell's analysis was infected with hindsight. So from the written report, the basis for this suggestion was the following. One starts with the agreed common general knowledge that at the start of a drug discovery project, the skilled medicinal chemist and the skilled cancer biologist would agree a TPP, see above 97. In cross-examination, Professor Westwell agreed that the skilled medicinal would would be conditioned by a TPP. We discussed with a skilled cancer biologist. The TPP is like, what is your target product profile? And in this case, there's just no issue arose in relation to it. Neither Professor Ward nor Professor Westwell thought the need to emphasise it on the obviousness analysis because it was common ground. What you were looking for was an androgen receptor antagonist that was efficacious on hormone refractory cells. That was the TPP. Obviously with satisfactory pharmacokinetic properties. So 291. Estella's point out that when it comes to evidence on obviousness, there's no mention of TPP either by Professor Westwell or Professor Hickson, or by Professor Clark or Professor Ward. I mean, it was a completely non-point. And it was never put to Professor Westwell that defining the TPP would have been differently or would have impacted his analysis of inventive step. That was just never put. It was just not explored. It was common ground that the skilled team were interested in androgen receptor antagonists. That was the beginning, the middle, and the end. And Professor Westwell's position was that it was obvious to arrive at the invention without performing an SAR. So then at 292, we see a reference that gets repeated. So the problem with Professor Westwell's evidence on obviousness is the absence of a proper description of context in which the team formed the view that it was immediately obvious. We'll come back to this. And then we'll come back to that because the judge comes back to it in a moment. Also, just note, it was never suggested by Stellus to the witness that it was obvious to do an SAR and that if you did that, that would take you in a different direction, or if you put that in the pot, somehow the obviousness analysis becomes different. That was never put. And then at 297, despite the sequence, it is curious that Professor Westwell's report was structured so that he presented his views on obviousness over the poster first, with immediately obvious wording. When it came to obviousness over the slides, he did not use that expression, and his reasoning was tied more closely to the material in the slides. Well, the reason is plain. Well, the reason is that there was the pairwise comparison between the dimethyl and the cyclobutyl in the poster. This made it immediately obvious. The fact that there is one of the things that made it immediately obvious. The fact that one is a nose ahead or the other or whatever, neither here nor there. The fact is you've got data that the dimethyl leads to a potent compound much, much better than anything that is the standard of care in the clinic at the priority date. And the slides, of course, just have a reference to a hydrophobic area on the pharmacophore. So if I can then go to 305, this is another Aunt Sally which we need to be careful about. Take forward RD7. So there's a heading. So this is, I think, 67 of the bundle. Take forward RD7. This was another route suggested in cross-examination of Professor Ward. It is the idea that the skilled team will look at the poster, not proceed with 162 or any optimization, but will instead seek to undertake a structure-activity relationship on RD7. This is something that comes from my learned friend's imagination. It doesn't come from anything that we said. My lords, I just need to, in fact, we disavowed it. So if I could go to our closing oral submissions, supplemental bundle, tab 14, and just, sorry, my lords, the reference in page on that. So it's bundle number 362, and it's the bottom right hand page, sorry, so 586 is the page, you see it, my submission, though this is in closing, you see it that 162 and 162 prime are incorrectly drawn. This is just right at the start, the outset of my submissions. That doesn't matter. Then it says, my lord, a few Aunt Sallies perhaps have been delivered this morning, explaining to my lord what our case is. Our case of obviousness is set out in the expert report, and that is our primary case of obviousness. We do not, in our opening or our closing, have a case that you would start with RD7. I'm not sure where that has come from. And my lords, we repeat that at 683, and Mr Lyciadopoulos acknowledges it in his reply at 699. My name, friend, makes it very...
You say 683, but we don't have 683.
Oh, sorry, so it's that. Sorry, it's in the next... It's the next tab, I beg your pardon. Under page 387. This line 5 is not our case taking forward RD7. Gets repeated there. So 387, 683, line 5. And then Mr Lyciadopoulos picks it up at 699. Line 8. My learned friend has made it very clear that he's not starting from RD7. I was therefore going to pass over this section. May have a few short comments on it later, but I'm going to pass over it. And go to 320. There are various... Sorry, my lords, I do apologise. I should just go back to... to 299. I do apologise, I just missed a... Judgment 299, which I think is page 66. There was discussions, again, these were matters trying to get through to Professor Ward and exploring motivations. He was saying it's the end of you'd never do anything. Chemistry in this area is finished. You wouldn't look at the poster, that's the end of the matter. And we were putting to him various ways one might be interested in taking it forward. Obviously we've got our legal argument, which is what we rely upon today, but that's why we're saying you might want to go have a novel compound, you might want to, patent department may ask you for what else is suitable. These were devices used to explore matters with Professor Ward. Sorry, my lord, I was then going to jump back to where we were at 320, page 70. Finally, it was suggested that maybe 162 would be progressed, but 162 prime might be alighted upon as a backout compound. Professor Ward explained this would be super risky for similar reasons as explained above. Estella submit that nobody makes backup compounds with the goal of them being structurally similar to the candidate compound. The idea is to have something structurally diverse, so too similar to make for a backup compound. We just raise a metaphorical eyebrow at that. There was then some secondary evidence dealt with after that, and this was resolved in our favour. There was a suggestion that work that Professor Westwell had done after the priority date had contaminated his views. That's rejected at 325. I did not propose to place any weight on this point because the context of the later work done by Professor Westwell was very different. So, my lord, we then come to the conclusions. This is obviously important. And pick it up at 336, which I think is 73 of your bundle. This case involves a somewhat unusual situation. Now, what was published in the poster was a molecule RD162 which showed good efficacy, good PK/DM properties. It was clear that the skilled team would regard RD162 as a good candidate to take forward into further testing. The motivation to consider other molecules came from competitive and patenting considerations, in the sense that it would be prudent for the skilled team to view RD162 as belonging to the authors. Now, we know it was patenting considerations which caused the patentee to jump horses. We know that from various emails that were provided to the court. But the important thing at this stage is motivations can come from patenting consideration, but that does not mean that alternative compounds are only obvious if they are patentable and will be in competition in the marketplace. My lords, we've seen the authorities on this, so it's not sufficient just to say the only reason for going forward are patenting considerations, particularly having rejected the motivation arguments put forward by Professor Ward. The fact is, if it's technically obvious, it's technically obvious. Then at 338, so obviously an important section, says I can start with the case as originally presented in Professor Westwell's first report. So the judgment has wandered through these various arguments, the SAR arguments, the Aunt Sally's, as we call them, none of which, and then he comes back to our primary case, rightly. And then he says there are a number of problems with this case. Professor Westwell does not explain the scenario in which the skilled team decides to take the step which he says is obvious. In particular, he does not explain why the skilled team starts by considering position X, nor why the skilled team starts to consider changing cyclobutyl at that position. Now, we say, first of all, he does. He focuses as a technical matter on the pairwise comparison. And he explains why.
Sorry, could you just repeat what you said there, because the transcript didn't get it and neither did
Yes, so it's wrong to say that, this may not be what the judge has been directed at, but it's wrong to say that he didn't explain the scenario. Because he explains...
Sorry, I'm really struggling. I've also got somebody
sorry, do I just need to speak up, my lord?
Yes, please.
Yeah, I beg your pardon. We say that the witness did explain the scenario. In that, he pointed to the pairwise comparison. He pointed to the fact that there was data on dimethyl, which showed it was much more potent than bicalutamide when put into the assay. So he didn't just assert it, he gave a technical explanation. That's the first thing. The obviousness of a compound with similar activity is enough. It's an obvious technical alternative, as Professor Westwell explains. And my lord will have in mind that there was no challenge to the technical reasoning that a compound with the structure of RD162' would likely have similar activity. There was no challenge to that. And that, we say, is enough. As a matter of law, the skilled person studies the prior art with interest. On looking at it, it was immediately obvious that changes could be made at position X because of the pairwise comparison. There was no substantive challenge to the technical reasoning which gave rise to that conclusion. Technically obvious alternatives are obvious and no additional scenario or context is required. You do not have to raise patenting considerations or anything like that. If it's technically obvious, it's technically obvious. Just as no context is required to say I could, in my shed, replace the nails holding the timber together with screws or adjust the size of my dinner plate. And the skilled team looking at the poster comprises a medicinal chemist who doesn't look at it to admire the aesthetics. A medicinal chemist looks at prior art because they're interested in AR antagonists, and indeed alternative AR antagonists that will be effective against hormone refractory compounds. That is their bread and butter, looking for active compounds. So then moving on to 3382, his answers in cross-examination indicate that he was not considering the situation where the skill team had decided to do an SAR. Yeah, absolutely. That was a matter which he said was a separate matter which you could do an SAR. That's a different ball game. And then just dropping down, instead his answers indicate he was asked to consider the change from cyclobutyl to dimethyl and ask whether that change would have a material effect. Even if I assume in his favour that he was referring to Pozzoli step 3, the invitation put to him was leading. The Pozzoli question can be described as leading, and for that and other reasons, one needs to be alert to hindsight. But the important thing is the fourth Pozzoli question, which and the witness followed, where you have to put the invention out of your mind. Never suggested to him he hadn't done that when he followed the Pozzoli structure. And we remind you that the same structure was used by Professor Ward.
So you say it wasn't put to him. Do you mean that in cross-examination it was not put to him at step 4, he had not put aside hindsight?
Yes, yes. All that was ever put to him, you've seen the passages, was that the Pozzoli, is that he followed Pozzoli. I mean, that's our interpretation of the cross-examination. Never said, no, you've made a mistake, you haven't followed Pozzoli. And you've seen what the judge was referring to when he used the word asked. If you go back to the judgment 205 towards the end, that passage of cross-examination, so if you just... It's at the end, he says, if I am asked about the change between cyclobutyl...
Sorry, the reference you gave was 205, which can't be right.
285.
Sorry, my lord. 285 of the judgment. I do apologise. 64 of the bundle. That was the passage of cross-examination we looked at. And if you just see where the word asked comes in, I asked about the change between cyclobutyl and gem-dimethyl. That's a line 24 on 159. Okay, and then the judge concludes...
Sorry, I'm lost.
Yes, let me take it more slowly. I do apologise.
Right.
My lord, there's
I've got to 285. I've got to 159 with the transcript.
Yes, and then you need to go right to the very end of it. So line 24. Line 23, there's a question.
Right.
So when you...
it's the bridging onto 160.
Yes. Yes, my lord, sorry. Not very helpful with that. That is right. So when you say the obviousness of that change, what you were thinking was, if I'm asked about the change between cyclobutyl and gem-dimethyl, do I think the change is an obvious one to make in the light of what I have here? That's the question asked, and the witness says yes. And then we see at 2873, the judge then says, and we've looked at this, when he was asked to assess obvious in terms of the difference between gem-dimethyl, and the judge goes on to say, well, he was just referring to Pozzoli. He might well have been referring to Pozzoli step 3. We say plainly he was referring to Pozzoli step 3. So then, having reminded ourselves of that, if we then go back to 338, instead his answers indicate he was asked to consider the change from cyclobutyl to dimethyl and asked whether that change would have a material effect. And he says, even if I assume in his favour that he was referring to Pozzoli step 3...
But where's the material effect question? Because what you've just read to us is a question, do you think the change is an obvious one?
That's I think, in his... Can we just get at the expert report and... Could you get him enough?
Well, this does not necessarily a point against you.
No. Clearly not. But just seeing if I can see the word material. I think those around me will look for.
Isn't this going back to the extract from the transcript you took us to?
Yes, although I think that's reproduced. The relevant bits are reproduced in the judgment, I think.
So,
285.
So my lord is suggesting that the reference is to the slightly earlier passage in the transcript. So it's 159 at line 18.
Yeah.
With that change in mind, you were then saying, well, is that going to have an effect or not, or make any obvious changes, which is kind of rolling up two questions into one, but there we go.
Yeah. Certainly this passage that the judge has in mind in my submission. And we have the, our submissions are that, look, at 2873, the judge is saying it's not inconsistent, I'm paraphrasing, not inconsistent with Bozzoli step 3. But then reaching this conclusion at 3382, and insofar as there is a suggestion that he was drifting off Bozzoli, there's no basis for that. And when the judge says, even if I assume in his favour that he was referring to Bozzoli step 3, the invitation put to him, so that's the invitation put to him by the lawyers posing the questions that he answers in an expert report, was leading, but the questions put were not leading, they were the Bozzoli test. One could see that from his expert report. And again, sorry, I'm repeating myself.
Well, there's two different questions. One is whether Bozzoli would be leading, and your answer is, as a matter of law, it can't be, because that's what we're required to do. In fact, as we all know, the real problem in this area is that hindsight is inescapable, because the party attacking the patent is allowed to choose the prior art, and as soon as you choose the prior art, which you do with hindsight, it's inescapable. And you are required to analyse the difference between the patent and the prior art, and that necessarily involves hindsight. And yet you're supposed to put that out of your mind, which is impossible. But that's where we are. That's the nature of the law in this area. So your submission is straightforward. Insofar as the expert applied Bozzoli, he was required to do that.
Yes.
His evidence would have been dismissed if he hadn't done that, and he can't be criticised. That point is clear, but that's not the point the judge is making, I don't think. The point the judge is making is a different one, and the question is whether it's well-founded.
Yes.
Because he interprets the cross-examination as indicating that the witness was asked to consider the change and then asked whether that change would have a material effect. Now, I assume you wouldn't dispute that if that was the exercise the expert was engaged in, that would be wrong.
Yes, so what the expert, obviously we can see from his report what he did.
That's a different question.
Matter, yes.
So we take it in stages. If that was correct, the witness would have, not necessarily his fault, but the witness would have fallen into error, correct?
Yes. But
your submission, as I understand it, in fact, is the cross-examination does not establish that.
That's right. There's those 2 points. And my lord, the other thing to remember, which is really crucial, we say, is all this cross-examination is on the slides. And the different considerations arise in relation to the slides. So the judge was wrong to rely on that cross-examination on this issue. My lord, if we can just see, I should show my lords what the cross-examination was on the poster. And can someone give me the reference? So tab 11, supplemental bubble, tab 11. What page of the bundle? 259. But there's some crucial differences in the two cases. And if we so 259 of the bundle, if we go to 179 line 16, as we so 179 259 of the bundle, as we saw before, this gives us a bit more information than we had in terms of the slide. So that's where he's introducing the poster in terms of compounds made. What we can see is they started with RD2 and they made a change to the right-hand side. Models are familiar with that. And then if we drop down to 180 line 14. Now, if you could go to your evidence on this, your approach here, so if we go back to C1, paragraph 949, so taking the witness back to his key passages, we discussed your phrase immediately obvious. In 950, you talk again here about how it is obvious that you could change the cyclobutyl to gemdimethyl to a cyclopentyl. It's unlikely to affect the therapeutic potential or activity. My understanding is that you approach this in the same way as you approached the slides, came to the same conclusion. And that's if my learned friend wanted to run this point that he hadn't applied Bozzoli correctly, that there was his analysis was leading, or that he hadn't.
There's two different things here. Yeah. One is application of Bozzoli, but the point you were trying to make before that was that the considerations are different. And of course, it's true that the content of the slides and the poster are different. That's not in dispute. But so far as the present issue is concerned, the witness's answer here is he adopted the same approach.
But he's saying no more than I follow Bozzoli. That's what he's saying, no more. I mean, the cross-examiner doesn't want to explore it with him. I mean, if this is crucial to my learned friend's case, it had to be properly put. So we're making good progress. We'll just go back to where we were. We were 3383, we're back on page 73 of the bundle. The judge then deals with the Aunt Sally. In this regard, there's no separate body of case law which is applicable if the change required to get from the prior art to the claim is said to be immaterial or trivial. I didn't use the word immaterial either. They are in speech marks, but they come from, again, they just come from my learned friend. That says you're saying they're immaterial or trivial, and now I'm going to tell you why that's wrong. And it has to be seen in that context in our submission. And then 3384. Here the judge is effectively saying you're not motivated to look for similar molecules, you're only motivated to look for different molecules because you're looking for different molecules to patent. Might not we say that's, in the context of this case, not an appropriate analysis. So, my lord, if I can summarise our position. The inventive concept is the use of the compound of structure RD162 prime, has the potential for use in treating prostate cancer, as assessed by its activity in certain assays and its PKDM properties. The difference between the patent compound and the prior art is the presence of dimethyl at position X rather than cyclobutyl. It's obvious, without regard to the invention, because of the pairwise comparison, that a compound with a dimethyl at position X will have similar activity to RD162 prime, to RD162, I beg your pardon. There was no technical challenge to the technical reasoning of, there's no challenge to the technical reasoning of Professor Westwell on any of these points. We say the judge has gone wrong in two ways. First, he has in effect held that taking the Bozzoli approach means the opinion is necessarily tainted with hindsight. I pointed out the various tensions we see in the judgment between the analysis at 287 and 288. and 338. And my Lord has had the submissions on the cross-examination. Second, we say he was obviously wrong. Wrong. Look for a scenario context other than that which is technically obvious. Of course, it is desirable to have compounds that are better than the standard of care in the art. And insofar as the judge alighted to a need for a TPP, there was nothing in this point for the reasons I have explained. And in any event, that point was never put in cross-examination. My Lord, can I then go to the judgment on the slides? Go to 371. That's page, I think, 80 of the judgment.
Come back to the second error, and I think I've got your submissions.
Yes.
Can we just explore it a bit further?
Yes.
Why does the skilled team reading the poster want an alternative to 162?
Yes. Well, they, for commercial reasons, they may not. They may or may not. They may want a competing product. They may not want a competing product. But the important point is they want to treat hormone refractory prostate cancer. And any compounds which are better than the standard of care are obvious for that use. That is what is driving the interest in this poster. If the evidence had been there was a concern was that these compounds are unlikely to be better than the standard of care, I'm just going to show minimal activity, if that had been established in cross-examination, then that would be a different matter. But there's no need for a scenario or context beyond the fact this is a very important disease and the research does not stop with a single compound. That's not where the interest in this art stops. So alternatives, and it's just like the obvious, that's why it is the analogies we draw with, right, replacing the nails with the screws or the screws with the nails or the glue. It's technically obvious. What the commercial drivers in the context of this case are is sort of neither here nor there. It is just technically obvious. So it is a bit like RIM in that respect.
Okay, so I think it follows from that way of putting the case that you say that the judge's rejection of Professor Ward's first reason is critical.
Yes, yes, absolutely.
Because the first reason is you wouldn't go anywhere.
It's the end of chemistry, yeah.
Thank you.
Can I go to the slides? So that's 371 of the judgment. The judge sets out. I can take this much quicker.
Sorry, just for my benefit.
Yes, yes.
Your first point, you said the judge went wrong because taking the Pozzoli approach necessarily means hindsight.
Yes.
Do you also say that insofar as the judge went further than that and said that the evidence was otherwise tainted with hindsight, there was no basis?
Exactly. Yes, my lord, exactly so. So if we can, I think we could just take the evidence from the judgment. I'm taking this much quicker, but it doesn't mean it's not an important case, an important aspect of the case. It says it's not it's a powerful case.
Well, can I ask you this question? I appreciate that they're independent pieces of prior art which differ in the ways that you've already described, and have therefore to be considered independently. But realistically speaking, if you fail on the poster, can you succeed on the slide?
It depends on the reasons why we fail, my lord. The slightly odd bit, if I can just jump to So if I go to 379, my lord, this is quite an important point. 379 of the judgment. Well, the judge, we've got closer, it seems we got closer with the slides with the judge. And at 379, the judge says, the obviousness arguments in this case were finely balanced. The more so in relation to the slides. I have changed my mind on obviousness over the slides more than once, because of Professor Westwell's technical reasons were cogent, and because his approach, which I infer was formulated before he saw the poster, was less clearly redolent of hindsight. Now the cross-examination the judge relies on is cross-examination, for the hindsight, is cross-examination in relation to the slides. And whereas we enthusiastically embrace the fact that there's no, it's clearly less redolent, it's not redolent of hindsight, we embrace that, of course. But it makes no sense in our submission that the cross-examination in relation to the slides can have more bite when it comes to the poster. Let me take it, I think the critical bit is really going back to 371. It is a different case. And can I just invite my lord to read 1033, the first half of paragraph 1033, it should be before we get to the pharmacokinetic properties. So that's the case as to why you'd move from cyclobutyl to dimethyl. And again at 374, at the end of 374, we see the technical reasons.
Can you just, so I've got it there, which of the slide are we looking at here? Slide 8?
Yeah, so if we go to supplemental bundle again, my lord, and go to, sorry, it was a little while ago when we looked at them. We go to tab 2. Obviously you've got the structures of RD37 in a number of places, but it's the slide at 10, I think page 10. Yeah, page 10 of the bundle, my lord. If you recall, what happens here is that there are hydrophobic interactions, and my lord see that in red, hydrophobic interactions with the receptor.
This is slide 8, is it?
Slide 8, yes. Yeah. Yeah. So page 10, sorry, rather. Slides don't actually have their numbers on them, but page 10. And so the witness is saying, well, if you know cyclobutyl works, it would be obvious that R1 and R2 could be methyl, as these would be expected to behave similarly to the cyclobutyl, being only slightly smaller. So they're both carbon and hydrogen. And then he explains why you'd have them both the same, because otherwise you'd introduce a chiral center. And then I can take this reasonably shortly. If one goes to 374 of the judgment, again, we have it's recorded at the end of that paragraph, the technical reasons are not challenged.
Well, look,
sorry, my lord.
I thought when we looked at this earlier, you said when we were looking at these particular features that the cyclobutyl was a better fit.
No, that was the case put against. That's the case being put against us, which was rejected by the trial judge. So you remember there were 3 reasons put by Professor Ward as to why the invention was invented. And one was you'd think there's a hydrophobic pocket and that the cyclobutyl is the right fit, a better fit for that, snugger fit for that pocket. That was a reason that he put. And the judge went at some length through the evidence on that and rejected it. So,
but we haven't looked at that.
we looked at the conclusion.
Did you look at it very briefly? Sorry, can you remind me where we looked at that very briefly?
Yes, so it starts at 268 of the judgment. And then the conclusion is at 274 and 275 of the judgment.
Sorry, yeah, maybe I missed it. We looked at this, did we?
I think we did. Maybe I gabbled over it, my lord.
Okay. Sorry, in which case I...
So the conclusion you did take us to is at 274.
Yes.
The position was there was no information upon which to reason that cyclobutyl was a better fit.
Yes.
Okay. Right. Yep. Right.
And as we see, the same point was made in relation to the slides. That was in relation to the poster. We're coming on to the slides. The same point was made in relation to the slides. I'll come to in a moment. But anyway, this is... if we now go to 377 of the judgment, Estella submitted that this is not an obvious thing to do. If you actually go to the expert report of Professor Ward, he runs all the same 3 points again in the same way. And that's at paragraphs 142 to 144. He runs the same 3 points. I'm not going to turn it up. Size of pocket, lack of motivation, metabolic liabilities. The judge here just deals with the pocket. And that's 3373. So the reference to hydrophobic interactions necessarily implies a pocket. And then at 4, he says a fair reading of the slides is that the cyclobutyl better fits the hydrophobic pocket and assists in the improvement over the early dimethyl agonist compounds. But having dismissed that in relation to the poster, because it's the same point, we don't understand why the learned judge has lost sight of that. And then,
well, at this stage, he's reciting the argument.
Oh yes. Sorry, I beg your pardon.
Look at the first sentence of 377.
Most unfair. I do apologise. Then it's the conclusions over the slides. Sorry, I'm getting ahead of myself. And the only conclusion that the judge reaches on the primary case is at 380. So he says less redolent of hindsight. And then at 380, he did not explain the context in which the skilled team would make considerations setting out his technical reason. That's it. That is the entire finding of the judge. Then goes on to SAR. So in cross-examination, Professor Ward strove to provide a context. The SAR starting from 162, that's of course not our case, not our primary case. And then 383, dealing again with this SAR argument, in view of my reservations about characterisation argument, came very close to succeeding. So we nearly succeeded on our secondary case. But 381 through to 384 is our secondary case. So it's just a single paragraph, 380. My submissions on that are the same. Well, I've just got one more point, if there are no further questions. I glossed over the section on RD7. I said this was never was our case, it was disavowed. Within it, can somebody just remind me where it is? RD7. Looking for it. Oh yes, 305, my lord. 305, as at page 67 of the judgment. That was now within this section, which I've not addressed on because it's not our case, there was some discussion about the relative activity that you could discern, in particular from the in vitro work disclosed in the poster. And just our position, I'll leave my learned friend, if he places reliance on this, I'll leave him to deal with it. But I just want to give a bird's eye view what our position is so he knows how to address it. First, even taking Professor Clark or Professor Ward's evidence at its highest, we're talking about marginal differences. This is between RD7 and RD37, and indeed RD54. We're talking about marginal differences, which may not be statistically significant. Second, whether one is nose ahead of the other does not form part of the judge's analysis of inventive step. Moreover, it was not a reason advanced by Professor Ward as saying why RD162' was inventive. And then the third point is Professor Clark suggested he would attach greater weight to the highest concentrations. So if we just pull out the poster one more time.
Sorry, I'm not quite sure why we're getting into this.
Well, I don't think
there's no respondents' notices there.
Yeah, I mean, it's the last point.
I mean, it's hard to see how there would be anyway, given that this is supposedly knocking down a case which you've made clear you never ran.
Yeah, can I leave it there? I think I'll probably see what my friend does on that. My lord, unless I just check it. My lord, unless I can be of further assistance, those are our submissions.
Thank you.
At the heart of the appeal is the proposition on the poster that the poster discloses that the change from a cyclobutyl to a gendimethyl at position X will have no significant effect on activity, and a skilled team would understand that from the poster. And behind, and what's relied on for that, is the evidence in chief of Professor Westwell, which it is said was not challenged, and which it is said the judge accepted. The reason it is said the judge erred, or a reason, is from accepting the technical reasons, it is said he should have come to a different conclusion. Now, my lords will understand that where one's on an appeal for obviousness, it's a paradigm multifactorial assessment, and as Lord Justice Lewison explained in the Fagier case, one of the problems is the trial judge has the whole of the evidence, the whole sea of evidence, whereas the appellate court will be island hopping. And this is such a case because what my learned friend has done is he's focused entirely on the evidence of chief of one of the skilled medicinal chemists, but has ignored what he said in cross-examination.
Well, I don't think he's ignored it. He's certainly taken us to some of it. You wouldn't say not all of it.
Not all of it. And that's very fair, my lord. And he has ignored what the biologists said. Indeed, listening to my learned friend this morning, it's as if biologists have no part to play in the team. And that was not the evidence. And in my submission, that is one of the points that goes to the lack of context. And when the judge looked at, and I'll show you the parts of the judgment, it's in the section that my learned friend did not want to go to, which he says he disavowed at his case, and I will show you that's not quite right. What the judge was looking at there was the evidence of the biologists who explained that on reading the poster, they would not think the two were an immaterial change, and that they would want to proceed with the cyclobutyl. Now that, firstly, obviously is important that the judge had before him in relation to the case that's being put before you, that they're both interchangeable, if I put it that way, or materially interchangeable. But it also goes to why the judge talked about lack of context, because Professor Westwell did not consider that side of things at all. It was in my submission, one of the reasons why my learned friend tried to plug the gap at trial with the SAR analysis, because if it's right that on reading the poster, one would not conclude that there is no difference between a dimethyl and a cyclobutyl, then one might have to have a reason why I would change it. Now, at trial, my learned friend said a reason would be a structure-activity relationship approach, which both experts accepted, medicinal chemist experts accepted, was a common general knowledge approach. But as the judge said, Professor Westwell also accepted is a broad umbrella term that covers many
it may
things.
just be me. It may just be me getting lost in the double negatives. Can you just repeat that submission to me?
One of the reasons my learned friend tried to plug the gap at trial was with a structure-activity relationship approach. And that is where, on reading...
No, it wasn't a question of not hearing. It was a question of not following the double negatives.
I was going to try and read it and remove double negatives, my lord. The point I was making, my Lord and Justice Snowden, is that what my learned friend tried to do at trial was to say that the skill team would undertake an analysis whereby one optimises the compound, and in doing so, if one likes, one falls upon the cyclobutyl or the gem-dimethyl as part of that analysis. So you're trying out different substituents on the molecule. And for that, the motivation, it's the case that succeeded in Pharmacia and Merck. The motivation is to do a structure and activity relationship analysis. And when you do that testing, you find the patented compound. Now that case failed and is not now advanced before this court. But if that's gone, and also has gone that the poster teaches that the substitution makes no difference to activity, then we say there is nothing left, and indeed that is behind the judge's findings. Now, before turning to the poster, if I may say a few words on the law, although there does not appear to be very much, if anything, between us. My learned friend took you to the Supreme Court in ICOS at JA tab 4, and we did not detect anything there that we would disagree with.
Well, even if you did, it's binding.
Well, of course not. But even in nuance or some way of avoiding that, we're not trying to avoid that. It is very clear that motivation usually plays a part, and Lord Hodge was clear on that. But also there can be cases where motivation has a lesser role to play. And my learned friend has focused on those cases both before this court and in the court below. In particular, Höchst-Celanese, the judgment of Mr Justice Laddie, where he referred to changing fixing means from glues to screws and not needing a motivation to change the prior art in that way, but nonetheless, even if there's no motivation, it doesn't make it inventive to do it. And usually it is because the difference between the prior art and the patent is either arbitrary or extremely trivial, and there's no motivation to make such changes. My learned friend referred to RIM and Visto, and in that case it was using a different common general knowledge internet transport protocol to transport data through a firewall. The prior art, Lotus Notes, used a bespoke RPC protocol to one port. The patent used HTTP. Although there's no reason to change Lotus Notes, it doesn't take invention to do so, because passing data through a firewall with HTTP was a very well-known thing to do. It is worth briefly looking at what Mr Justice Floyd, as he then was, said in Rim and Visto, and if I may trouble you just to go to JA bundle tab 3. Page 118. Here, the learned judge explained that the question often arises as to whether the absence of a particular motive is fatal to an obviousness attack, and he said it's now to be regarded as settled law than is not, and he referred to Pharmacia and Merck, where Lord Justice Aldous, he said, cited with approval a passage in Mr Justice Laddie's judgment in Herc-Celanese. The court, as we have seen and now will briefly go to, Lord Justice Aldous did not entirely cite the passage with approval, but the point that Mr Justice Floyd was making was approved. The court will readily assume that technicians and businessmen will wish to make trivial changes. That is not to say motive is irrelevant. It's one of the many factors that has to be balanced in answering the statutory question. And my learned friend said today that one of the points he calls Aunt Sally's, that we had characterised their case as trivial changes, and the judge had referred to it. It did arise because the cases they were relying on before the judge, such as this one, characterised them in that way. So it's not our characterisation or even Mr Justice Mellor's characterisation. It comes from the authorities my learned friend relied upon. One has to be slightly careful about what is said there, and therefore if one goes to tab 2, which is Pharmacia and Merck, page 79 of the bundle, and this is the passage that my learned friend took you to, where at paragraph 123, Lord Justice Aldous records an argument of Mr Kitchen, QC as he then was, where he was submitting that the judge had failed to realise that to find the invention obvious, it was necessary to conclude there was an obvious reason or purpose to make the compounds of Claim 1, and that is where the quote from Mr Justice Laddie is set out from Herc-Celanese. Of course, as one sees at the bottom of that, although Mr Justice Laddie had set out that it can be cases where one does not need motive, and he refers to the 5¼ plate and the different fixing means for wooden parts, in fact, in Herc-Celanese, that failed. You see that at the end of his quotation, or the quotation, because it was not and could not be suggested that in that case, the changing a medium of aqueous to organic and a different resin was sufficiently trivial. And what was then said by Lord Justice Aldous was the statement of the law was apt on the facts. A step from the prior art, albeit without reason, can still be obvious. The Court of Appeal did not think that the reference to workshop modifications may be appropriate because it could be a gloss on the statute, and the statutory test is obvious, and any modification which is obvious will not be patentable. And then, as he goes on to say, whether or not there's a reason for taking the step may well be an important consideration, but it does not mean it's an essential requirement for the conclusion of obviousness. Now again, in this case, this was a case where in fact there was motivation, as he goes on to say. In any case, the judge in these proceedings did consider there was a reason for taking the step from the prior art, which was the natural desire to investigate the analogues and the structural activity relationship of such compounds. In that case, the evidence was that it would be obvious to wish to investigate close analogues of the prior art, and you see that at paragraph 137 on page 83. And at paragraph 141, the Court of Appeal held it was open to the judge to accept that evidence. Now, the evidence in this case was different, and my learned friend do not pursue the obviousness to do a SAR, structure-activity relationship. Now, in the present case, the judge considered the role of motivation, and if my lords would turn to the judgment in Core tab 1, page 47 of the bundle. And at paragraph 202, he sets out Lord Hodge in Activist and ICOS, where motivation is a relevant consideration and that the skilled person is not assumed to undertake technical trials for the sake of doing so, but has some end in mind. He then refers back to Mr Justice Kitchen, as he then was, a famous passage from Generics and Lundbeck, which my learned friend took you to, and is quoted where motivation is usually important. But the judge also recognised that there are cases where motivation plays a lesser role or is not determinative, and then he gives the examples where the prior art is the change is arbitrary or entirely trivial, where the prior art does not teach away or is neutral, meaning that the need for motivation to take a particular step might not play a part in the analysis. And he talks again about the plate diameter. Now, he then says that we had submitted that one has to be careful in a chemical or pharmaceutical context, and he deals with that at paragraph 210, where he says the problems in applying such a case to a case of chemical substitution are plain. If such an approach is applied, it truly must be obvious that the change will make no material difference, i.e. it's obvious the components of the issue can be swapped without concern or impact, and we say that is fair. This was the case in Rim and Visto. It's obviously the case of plate diameters and fixing means. And as we'll see, he then considered that a matter. Now, we say nothing about the judge's approach in law is wrong. The question in this case is the application to the facts. Now, before we turn to the poster, if just before the short adjournment we have a look at the patent and what the technical contribution of the patent was found to be, and it also impacts on the biologist approach to the poster, which the judge accepted. And the judge considered the patent at the end of the judgment, and we can pick it up at page 85 of the bundle. And my learned friend took you to figure 21 in the patent, which is the part of the patent where a PSA absorbance test is set out, and that is indicating the ability of the compounds to inhibit prostate-specific antigen, and the evidence was that a compound that can inhibit PSA is a good candidate for taking forward. And as I'll show you, the evidence was the judge accepted that the biologists would be interested in the one at the highest concentration. And here you see different concentrations of nanomoles, and the 1,000 and 500 are shown, or are lower concentrations as well. And there was a dispute over whether the skilled biologist would be more interested in IC50 values, which is what my learned friend has been referring to today, a measure of potency and how much of a substance is needed to inhibit a biological process by 50%, or PSA inhibition. And he did submit to you that only the IC50 was said to be common general knowledge. And we don't accept that, and just for my Lord's note, I don't think we need to show it up, but PSA is discussed in the judgment at paragraphs 88 and, well, actually 84 to 88 as part of the common general knowledge section.
Sorry, I'm utterly failing to understand the point you're making. Of course, PSA measurement is CGK, and no doubt the judgment recognises it's well known to give false positives, but that's by the by. But the question is, by what assay are you measuring ESA? I mean, you know, we're told ELISA, fine, but what is the point you're making?
The point I'm going to make, my Lord, is when we turn, I was going to show, my Lord, what the evidence was that the judge accepted on this, and it's the same approach, actually, that both biologists...
Well, why don't you take us to the judge's conclusion, and then the point may become clearer, because at the moment it's as clear as mud.
Apologies, my Lord. In that case, if my Lord turns to paragraph 415 on page 87. what he concluded was that the skill team would want to see IC50 data before drawing conclusions, but acknowledging those data were not provided. Professor Hickson appeared to agree with Professor Clark. The skilled cancer biologist would be interested in this stage at the maximal blockade and would want to identify a compound that is highly active. Professor Hickson agreed high potency at this stage would be indicative of an interesting compound, and as I will show you, the same approach was taken by the biologists to the poster. Professor Clark's evidence on what a skilled cancer biologist would take from figure 21, the question was something my learned friend said today was important, that nowhere do the inventors in the patent say that 162 prime may be superior to 162. It's not a conclusion the inventors have drawn. And Professor Clark's answer is it's evident from graphs 21A and B. There is a signal that is better. Clearly it would need further testing. What a skilled biologist, particularly someone dealing with prostate cancer all the time, would be looking for.
Where are you?
Paragraph 416 in the quotation.
Right.
Maybe, my lord, I was just reading that quotation in paragraph 416, what a skilled biologist, particularly someone dealing with prostate cancer all the time, will be looking for is the best agent which produces the best anti-cancer effect in this setting. And then, when the judge points out the same effect, he, from line 19 of the next quote in 417, he's looking at the higher doses and says, that's the 500 and then 1,000, because there are two experiments here. And he says, if one was to ask me if you're going to pick a winner amongst this lot, what would it be? It's 162 prime enzalutamide. Accepting fully, you have to test for its other properties. Now, following on from that, the judge concluded, and it's not been appealed, that the disclosure of enzalutamide in the patent made a technical contribution and was a technical advance, and that is in his paragraph 414. And I will show you that the biologist took the same...
That doesn't say that.
444?
Oh, 444, right.
Apologies for 441.
At the very least, 162 prime was a plausible alternative model to 162.
Yes, at the very least. But he also goes on to say, this was because he was looking at plausibility, it will work and does work, and the provision is a technical advance. But, my lord, when we come to the post...
I thought the point you were trying to make, and maybe I misunderstood you, was that there was a finding by the judge that 162 prime was better than 162.
The finding of the judge, he sets out the evidence at 416 and 417 and says that the criticisms at 418, the criticisms led by the claimants were unfounded, or they lost any real significance, read the error bar. So that was the criticisms, you can't read anything in. The point I was making, actually, my lord, which I'll come and develop on the poster, is the biologists, what's important is the PSA testing and at the higher concentrations. And that is why, when we get to the poster, both the biologists, the skilled chemists accepted it was for the biologists to consider, and the biologists accepted...
Yeah, but again, if we look at 443, I outlined the claimant's position opening and closing above. Their proposition was the patent had to show was plausible that 162 had better properties than 162 prime had better properties than 162, blah, blah, blah. And he says the claimants were focusing on the wrong question. So where is he finding that 162 prime is better than 162?
My lord, he finds, well, my lord, what he finds is what, the reason he says that they don't have to go better is he said that one doesn't...
He says it's the wrong question.
It's the wrong question. I accept that, my lord. What I'm pointing out is that the approach of the experts to figure 21, as I will show you after the short adjournment, is the same as the analysis of the assay in the poster. And both experts, and the judge made the findings, said that it shows that the difference makes a difference to activity. So changing a cyclobutyl to gem dimethyl matters to activity. That is the teaching of the poster. That is what was attacked by us, because, as I will show you, there are two sides to the poster teaching. One are changes that matter to activity. The second are changes that matter to pharmacokinetics. Professor Westwell assumed and said the poster says that activity will not change materially, and then focused on the pharmacokinetics. The change will not impact on the pharmacokinetics. We did not challenge and do not challenge that a change at position X would be thought of as likely to alter pharmacokinetics. That's all on the right-hand side of the molecule. We do challenge, and indeed the judge made findings in our favour.
I assume there's a missing not in that sentence.
Would not, yes. We do challenge, and the judge found in our favour, that Professor Westwell was correct, that reading the poster indicates no material change to activity, which is the heart of my learned friend's case. As I will show you, Professor Westwell did two things. Firstly, he accepted that on the face of the poster, cyclobutyryl has greater activity. He accepted on whether it was right to try and assess IC50s or PCA was not a matter for him, but a matter for the biologists. And the judge found that the biologists' evidence was that cyclobutyryl would be thought of as more promising in activity. And Professor Clark's evidence is it would be where he would put his money. But the heart of this appeal is there is no difference materially between them on activity. And the important, what's merged, is the assessment of pharmacokinetic changes, or changes to pharmacokinetics and activity. And I'll show you that that division was very clear in Professor Westwell's evidence, and the judge did not accept it.
All right, we'll do that at 2 o'clock.